Hi everyone, this is Matthew Lyman coming back to you from the Landlord Advocates, where we help landlords become better landlords. Our videos are directed at landlords, property managers, real estate investors, but today's video, we also include tenants. We want to talk to the good tenants and the bad tenants, and we'll define what we mean by that. But landlords, we also want to give you a bonus. Now later on in this video, we're going to show you how you can acquire a judgment for the back rent against your tenants here in New York, regardless of whether or not they are on unemployment, eligible for unemployment, or facing a financial hardship. Later on in the video, we're going to show you how. I'm not only the host of this channel, I'm also the president of Ideal Legal Support Services, LLC. We are a business here in New York that's been around for almost 30 years. We help landlords with all facets of landlording and being a better landlord. Well, a big part of that is evictions. We have facilitated thousands of cases in many courts in upstate New York, and we have facilitated the eviction of tens of thousands of tenants in those same courts over the last close to 30 years. Over the last few months, our process servers have been out serving notices on tenants for non-payment of rent, pay or move, or another notice, a 30, 60, 90 day to just leave. Our servers have been faced with a lot of negativity, screaming, hollering, being swore at, threatened, told things that are not the facts. And we're going to go into that in just a moment. But first, we want to talk to the good tenants. Who are they? Those are the tenants who keep an open line of communication with their landlord. They're the ones that are trying to pay the rent, making payments, or maybe even paying the rent in full. Those are the good tenants. We're talking to you. What you're doing will help you tremendously in the future. The future being when the landlord decides to take his tenants or her tenants to court for not paying rent. The likelihood of you going to court for that, more than likely is not going to happen. Because you are doing the right thing. You are talking to your landlord. You're paying. You're doing the right thing. That's what we have to say to you, the good tenant. Not much more. But we invite you to continue to watch this video. Because we're going to be talking about the other tenants, the bad tenants. You may know who they are. They may be your next door neighbor. They may be the person up above you or underneath. Watch what we have. Listen to what we say. And maybe impart that knowledge to those tenants. They may be your friends. So that hopefully they will not be put out in an eviction because they thought the wrong thing and did the wrong thing. So continue to watch if you like. Thank you. Now for those stories, those horror stories that our process servers have said, the screaming, the hollering, the being nasty to, the vulgarity, the threatening, some of the things that those tenants have said is that Governor Cuomo said that you can't evict me right now. Governor Cuomo says, I don't have to pay the rent to you. You have thought in your brain that no services, no notices can be served upon you by anyone. But that's not the case. That's not the case. Now, here in New York, there are processes that may differ from other states. So you are faithful landlords, subscribers. Talk to an attorney in your municipality, check with your municipality to see what you have to do in order to get your tenant into court for that eviction. Now, Governor Cuomo did not say you did not have to pay your rent. You still have to pay your rent. There is an eviction moratorium, yes, which means you can't be evicted until August. But that's not necessarily the case. What he means is that you are facing a financial hardship, or you are eligible for unemployment or collecting unemployment. Doesn't mean the landlord cannot serve you notices. It doesn't mean that you may not be in court by then. It just means that you meet those variables. You may not be put out until the end of August, beginning of September. Those notices that are served upon you are called predicate notices. The notices that you believe cannot be served upon you at all absolutely can. Here in New York, there are two sets of predicate notices. The one is for non-payment, and the other one is for a holdover. Right now we're going to talk about the non-payment. Here in New York, you are presented with a rent reminder and a 14-day. The rent reminder is provided to you from the landlord through a process serving business, through an attorney's office, through a firm such as ours. You would get that rent reminder, which will be given to you 5 days after your rent is due. So it's due on the 1st, you would get that on the 6th, the 7th, the 8th. And that's just a friendly reminder to say, this is how much you owe for this time frame, and please pay. The 14-day notice can be served upon you at the same time. That is a time frame of 14 days that you have to pay that rent or move out. If you do not do either, the landlord can take you to court to explain to the judge why you haven't done either one. Now here, because of Executive Order 202-28, enacted by Governor Cuomo on May 7, 2020, says that there are variables that the landlord must meet. And if they're not met, they cannot evict you. Well, we're going to explain a little bit later how that is not necessarily the case. That would be an unemployment claim, that you're on unemployment, that you file for unemployment or a financial hardship. But the notice is still can be served upon you. It is up to you, the tenant who chooses not to pay, when the landlord gives you that notice or has that notice served on you, it is your choice to make the payment to the landlord, make arrangements with the landlord, and get on the good side of being a tenant so that you don't face an eviction. It is your choice to do that. Now yesterday, one of our subscribers had asked the question, what does Governor Cuomo mean by a financial hardship? And we told her that actually was the topic of our next video, hence the one that we're doing right now. What is a financial hardship? Is it the spouse and spouse, one is working, one is not? Can they go to court and say, well, my spouse is not working? Well, has that been the case for 5 months, 8 months, a year, 5 years, 10 years, 30 years? If so, then that scenario where one working and one not was present well before the coronavirus pandemic. So therefore, that really should not be able to be utilized as a financial hardship. Is it a financial hardship that the groceries that you buy are more expensive than they were before the virus, before this COVID-19 crisis? Well, if they're more expensive for you, they're more expensive for everyone else. Is it a financial hardship that you had to buy a face mask or a handkerchief to cover your face? Is that a hardship? Is it a hardship that you had to buy hand sanitizer to make sure your hands are nice and clean? Is that a hardship? That would be a very hard hurdle for landlords to jump in court in order to prove that they were not suffering a financial hardship. The legal documents that are produced that would be served upon the tenants, that is signed by a court clerk or signed by the judge or signed by your lawyer, would have to have wording in that to mention the fact that they're not suffering because they're working full time, that they're not suffering a hardship at all. That wording needs to be in your paperwork. Again, consult with an attorney. Consult with, if you're from the capital region, consult with our firm, and our lawyers will help you get things done the right way. Now, one of the things that we proposed in our last video is that landlords, property owners, investors, property managers talk to Governor Cuomo's office. Because in his daily press briefing on May 7th, he stated that the $600 additional payment made by the federal government to those on unemployment was a one-time payment only. Well, it's not. It's $600 per week through the end of July 2020. Therefore, it's not a one-time payment. It's much more than that. And our argument on previous videos and today is that those who are collecting unemployment and the additional $600 every week are actually bringing home more money than when they were working. Therefore, with that more money, why is the rent not being paid? They're having more money come in, so it should be easier to pay the rent, should it not? But again, we have to look at that financial hardship, whether they're on unemployment or not, eligible for unemployment or not. When it comes time now to take this to court, even though you may be experienced, Mr. and Mrs. Landlord, it might be in your best interest to hire a lawyer to help you through this process in court. Because they've studied these, we've analyzed them, my team and I, we've analyzed these to find better ways to help you get what it is that you want in court. Now there's another notice that is served upon tenants. That is called a holdover notice. A non-renewal of the lease or non-renewal of tenancy. That is what we call a 30, 60, or 90-day notice here in New York. Let's look at it as if you have a lease. If you have an active lease. If you have an active lease, let's say it goes to the end of December, and you want to evict your tenant because you just don't want them there. If you do not have an opt-out clause in your lease, then your notice served upon them will have to give them to the end of December because you do not have an opt-out clause. But if in your lease they are violating sections of the lease, you can give them a 30-day notice to correct that. But on that notice, you need to state what section they're violating, how they're violating it, and give them 30 days to correct that violation. If they do that, it ends there. Now the opt-out notice, what's he talking about an opt-out clause? An opt-out clause in this lease, well, what does he mean? It basically is that it gives you, the landlord, the right to terminate this lease for no cause or reason with the service of the appropriate notice mandated by law. The wording of that opt-out clause, again, should be done by an attorney, a lawyer, or by our firm, because our lawyers can help you with that. Then that way that protects you. If you don't have that, then it's a 30, 60, 90 day. If it's a 1-year lease, it's a 60-day notice. If it's a 2-year lease, which you should never ever have a 2-year lease, it's a 90-day notice. If you have a month-to-month lease, it's a 30-day notice so long as they live there less than a year. Now let's say you have no lease whatsoever. It's just a month-to-month oral agreement that they're going to pay the rent to you when they do, and everything's fine, but you just don't want them there anymore for whatever reason, which is your right here in New York State. You don't have to have a reason. You have to look at the length of tenancy in that occupancy, of that dwelling rather. Had they been there for less than a year? If so, it's a 30-day notice. If they've been there for more than a year, it's a 60-day notice. If they've been there more than 2 years, it's a 90-day notice that you have to give them. No reason needs to be given. You just want them to move out. Now that notice is not the date of the notice or the date that they are served. It's a calendar month. So for instance, you want to evict your tenant, they've been there more than a year. If you give them a notice now, that gives them until the end of July to move out. If they don't move out, you can take them to court on a holdover eviction. Now again, in those court documents, there should be a wording that you will seek the rent for their fair use and occupancy of the dwelling after the termination of their tenancy, which is the 30, 60, 90 day. Again, your lawyer can draw up that paperwork and have that wording in there so that, let's say you're in court in September, the court may be able to grant you the rent for August and September's rent. Let's see what happens. Let's see if that will happen for you. But then, we have to look at the other aspect. And here's that point I mentioned, alluded to earlier on in the video, is how can I get the rent that they owe me prior to that? Because in a holdover, you can't mention the prior rent. It's not a part of the eviction. You can't mention it. It's only the rent after the expiration of that notice in a holdover. But here's how you can get it done. Here's how you can get it done, Mr. and Mrs. Landlord, property manager, real estate investor. You take the tenant to small claims court. In small claims, you will mention the back rent that they owe you. And I would even dare say, mention, if it's 60-day notice, mention those 2 months. So you had the papers, and you go to the court and you pay the filing fee for small claims, and they owe you February, March, April, and May. I would include June and July in the small claims form. Then that way they're in court, you may be able to get those months. If they paid you, then you would amend your petition down to the actual amount that's owed. And then that way it bridges the gap between that month or 2 or 3 months that you file small claims. The court that you would have that small claims in is more than likely the same court that you would have the eviction in. I say more than likely because there's a little difference. If you wish to sue them for more than $3,000, you have to do that in a city court. If your claim is for less than $3,000, you can do it in a town or a village. For instance, in Albany County, if your tenant owes you $4,000 in back rent, you cannot sue them in the town of Colony where the eviction may happen, but you can sue them in the city of Albany. Same thing if it's Saratoga County. Your tenant owes you in the village of Galloway, but it's $4,000. You can sue them in the city of Mechanicville or the city of Saratoga Springs. Schenectady County, they owe you $4,000, $5,000. In the town of Rotterdam, you would file your claim in the city of Schenectady. These are all upstate counties. You would file your claim there. If you win that amount, which I can't see why not, they didn't pay the rent, when is their defense? In a small claims court, those other defenses really cannot be raised. They just didn't pay the rent. When you win that judgment, you can collect on that. You can get the eviction on the holdover, and you can get a judgment for the rent in a small claims case. Now you might say to yourself, well, I've won, now what do I do? How do I collect? Well, we're going to tell you how in a future video. And how you can collect that rent, how you can collect on that judgment, how you can get your money back. But it is in your best interest to know as much about the tenant as you can. Know where they work, their employment, verify that, know that information, and that will help you later on. The bad tenants that we have just spoke to, we don't like calling you a bad tenant. We don't want to call you that. We want to call you a tenant that may need some help, that may be misdirected in their thoughts. The landlord doesn't want to evict you any more than the good tenant. He wants to keep you there. She wants you to stay and just pay your rent. We hope that the information that you have heard in this video will help you to make the right decision, to speak to your landlord, pay what you can so that you can stay in the apartment, so that when the courts do reopen, which some are opening now, the landlord does not evict you for not paying your rent. You may be angry right now. You may be saying, this man is angering me. Well, sit back, relax, think about it. Drop your pride, drop your anger, and do the right thing, and the right thing can be done for you. Keep in your apartment. We ask all of you, feel free, send us your comments below. Anything. We respond to comments. Let us know what you think, what you're happy with, what you're not happy with. Ideas for future videos. What do I do now in this crisis? Ask as a tenant, ask as a landlord. Subscribe to our channel. As other YouTubers say, smash the like button that you like the video. Hit the notification bell so that future videos you will be made aware of when they are produced. Look at the videos that we have produced now. We hope that you will learn from them, grow from them. That is our goal here at the Landlord Advocates. Until then, we wish you well.